Right.
Powers of the President, Chapter 3.
We've covered the legislative branch, which makes the laws. Now let's turn to the executive branch in Chapter 3, focusing on the powers of the president. In the realm of domestic law, the president's primary role isn't as a creator of new law, but as an enforcer. How does that distinction play out in their day-to-day actions?
That's the bedrock principle of the executive.
Mhm.
The president has the power and the duty to take care that the laws be faithfully executed. So enforce, but critically not make the law.
Right.
This means the president wields significant influence over administrative agencies, which are the federal bodies tasked with implementing and enforcing federal statutes. The president can issue executive orders to guide these agencies, setting their enforcement and rulemaking priorities.
Okay.
However, this power isn't without limits. It's constrained by congressional statutes. The president cannot direct agencies to enforce a law in a way that exceeds its statutory mandate or, directly contradicts what Congress intended in the law.
And what about the president's very distinctive power to pardon? How far does that reach? Is it unlimited?
The president's pardon power is quite broad but very specific. It applies only to federal offenses. It can be exercised at any time after the commission of the offense, whether before or after conviction. However, it does not extend to state crimes, nor can it apply to cases of impeachment. It's a powerful tool for individual relief, but only within the federal system.
Okay, federal crimes only, not impeachment. Got it. The veto power is perhaps the most visible way the president influences legislation. Can you walk us through how that process works once a bill lands on the president's desk?
Sure. Once a bill has successfully passed both the House of Representatives and the Senate in identical form, it must be presented to the president. The president then has 10 days, excluding Sundays, to act. They can sign the bill and boom, it immediately becomes law.
Simple enough.
Alternatively, they can veto it, sending it back to the originating House along with their objections. Congress then has the opportunity to override that veto, but it's a high hurdle. It requires a 2/3 vote in each House. Not easy to do.
Very difficult, yeah.
Mm.
What happens if the president just doesn't do anything within those 10 days? Does it automatically become a law, or does it just die?
It depends on whether Congress is in session. If the president does nothing and Congress is in session, the bill automatically becomes law without the president's signature after those 10 days.
Okay.
However, if Congress adjourns within that 10-day period, preventing the bill's return, and the president does not sign the bill, it does not become law. This is known as a pocket veto, and Congress cannot override it because they are no longer in session to receive it back.
Sneaky pocket veto. All right. And how about the president's power over federal personnel appointing and removing officials? That seems like a massive source of executive control.
It is a significant power, absolutely. The president has the power to appoint all officers of the United States, think U.S. Supreme Court justices, cabinet secretaries, ambassadors, high-level agency officials. However, these principal officers require the advice and consent of the Senate. Confirmation hearings.
Right.
When it comes to removal, the president generally has the power to remove any executive appointee, essentially at will, without cause and without Senate approval. This is seen as key to controlling the executive branch. There is an important exception for officials in certain independent agencies where Congress can, by statute, require good cause for their removal, ensuring some insulation from direct political pressure for those specific roles.
Okay, like the heads of regulatory commissions sometimes.
Exactly, like the FTC or FCC commissioners, potentially.
So how strong is a president's executive action in any given situation? It seems to vary immensely, largely depending on whether Congress is weighed in or not.
That's precisely the framework laid out by Justice Jackson's famous concurrence in the Youngstown Steel seizure case, which is absolutely critical to understand for the bar.
Yeah.
It defines 3 zones of presidential authority.
Zone 1.
Zone 1. When the president acts with express or implied congressional authorization, they are at their maximum authority, and the action is likely valid. This is the strongest position for the president. Congress is on board.
Okay, Zone 2.
Zone 2. When Congress has remained silent on an issue, the action falls into a middle zone, a zone of twilight, as Jackson called it. Its validity here depends much more on the specific facts and any concurrent historical practice or inherent executive powers. The president is relying more on their own independent power, and it's a much more precarious position.
And Zone 3, the weakest.
Zone 3. When the president acts against the express or implied will of Congress, they are at their lowest ebb of authority, and the action is likely invalid. This is where the president is essentially defying the legislative branch, and courts are highly unlikely to uphold such an action. This spectrum is really key to analyzing executive power questions.
That Youngstown framework is super helpful. Beyond domestic matters, the president is also our chief global actor as commander-in-chief and in foreign relations. How do those powers operate, especially when it comes to military action or international agreements?
The president has substantial foreign affairs powers. As commander-in-chief, while only Congress has the power to formally declare war, the president can take military action without such a declaration in cases of actual hostilities against the United States, or, arguably, to protect national interests abroad. It's a source of constant tension.
Yeah, seems like it.
However, Congress retains a powerful check through its military appropriation or funding power. Congress can effectively limit these activities by controlling the purse strings. No money, no mission.
Right. And what about international agreements like treaties and executive agreements?
Yeah.
How do they fit into the hierarchy of law when they potentially conflict with other legal sources, like state law or federal statutes?
Good question. The president has the exclusive power to negotiate treaties, but these require ratification by a 2/3 vote of senators present. A fundamental rule is that a treaty cannot conflict with the Constitution. If it does, the Constitution always trumps the treaty. Treaties are on par with federal statutes. The later in time generally controls if there's a conflict between the two.
Okay. And executive agreements, those don't need Senate approval, right?
Correct. The president can also enter into executive agreements with foreign nations. These are distinct because they do not require Senate approval. In terms of hierarchy, conflicting federal statutes and treaties take precedence over executive agreements. So they are below statutes and treaties. However, executive agreements do take precedence over conflicting state laws.
Okay, so the hierarchy is Constitution, then treaty statutes, last in time wins, then executive agreements, then state law.
That's the general hierarchy, yes. Remembering that tiered structure is a common point of distinction for bar exam questions. R4, Federal Interbranch Relationships, Chapter 4.
Now let's explore Chapter 4, Federal Interbranch Relationships. This section zeroes in on the delicate system of checks and balances, specifically looking at how Congress keeps the president in line. What are the key tools Congress has at its disposal to check the executive branch?
Congress has some very potent checks on the executive, really demonstrating the separation of powers in action. The most dramatic, of course, is impeachment.
The big one.
Yeah. The House of Representatives has the sole power to impeach, meaning to bring formal charges against the president, vice president, and all civil officers of the United States. This requires just a simple majority vote in the House.
Okay.
If impeached, the Senate then conducts the trial and can convict by a 2/3 vote of members present. The consequences of conviction are strictly limited by the Constitution: removal from office and or disqualification from holding future federal office. Importantly, criminal penalties do not attach through the impeachment process itself. It's fundamentally a political, not a criminal proceeding.
So impeachment is a political mechanism, a check, not a criminal trial.
Yeah.
What about Congress's power over money, specifically appropriation? How does that control presidential spending? Can the president just refuse to spend money Congress allocated?
The power of the purse, it's immense. If Congress explicitly mandates the expenditure of funds through an appropriation bill, meaning they clearly direct how money must be spent, then the president generally cannot impound those funds by simply refusing to spend them. The president cannot unilaterally substitute their spending priorities for Congress's when Congress has clearly spoken with mandatory language.
So if Congress says spend this, the president has to.
Generally, yes, if the language is mandatory. However, if there's no such explicit mandate, if the appropriation is more discretionary, the president may have more leeway to decide whether or how to spend the allocated funds. It often comes down to the specific wording of the statute.
Okay. And what about legislative vetoes? These seem like a direct way for Congress to maintain control over executive agencies without passing a whole new law. Are they permissible? Can Congress give itself a veto over agency rules?
No. It is definitively unconstitutional for Congress to attempt a legislative veto of an executive action. A legislative veto is when Congress tries to retain direct control over an executive agency's actions. For example, by requiring an agency rule to be approved by a congressional committee after the law is passed, or allowing one house of Congress to nullify an executive action without going through the proper constitutional legislative process. Which is bicameralism, passage by both houses, and presentation to the president for signature or veto. The Supreme Court, in the Chadha case, consistently struck these down as violating the separation of powers. Congress can't give itself a shortcut around the prescribed lawmaking process.
Got it. No legislative vetoes. Can Congress delegate its lawmaking authority to others, like the executive branch or administrative agencies? That happens all the time, right? Where do we draw the line?
Yes, Congress may indeed delegate some of its legislative authority, and it does so frequently, especially to administrative agencies. However, there's a crucial limit, theoretically at least. Congress must specify an intelligible principle to guide the delegate.
An intelligible principle.
Right. This means Congress has to provide clear standards, rules, or guidelines for how the delegated power is to be exercised, preventing completely unchecked authority. In practice, the courts have been very deferential and found an intelligible principle in very broad delegations. However, certain powers are considered absolutely non-delegable, meaning Congress cannot hand them off at all. Examples include the power to impeach or the power to declare war. These are core legislative functions that only Congress can perform.
Okay. Moving on to immunities and privileges, who enjoy special protection from civil or criminal liability within the federal government, and why is that necessary?
There are distinct immunities designed to protect the functioning of each branch. For judicial immunity, a judge has absolute immunity from civil liability for damages resulting from their judicial acts, things they do as a judge in a case. This protects judges from harassment for their official decisions and allows them to rule without fear of personal repercussions for their rulings.
Makes sense.
However, this immunity does not extend to non-judicial activities, such as, say, hiring and firing court employees or administrative tasks. For legislative immunity, under the Speech or Debate Clause of Article 1, members of Congress have absolute immunity from civil or criminal liability for statements made and conduct that occurred in the regular course of the legislative process, speeches on the floor, committee work, voting, etc. This provision ensures robust debate and legislative action without fear of retribution or prosecution based on their legislative acts.
And the president, as the head of the executive branch, how broad is their executive immunity? Are they immune from everything while in office?
The president enjoys a significant level of executive immunity. They have absolute immunity from civil liability regarding any act performed as part of their official responsibilities while president. This is deemed crucial for the president to carry out their duties vigorously without constant fear of lawsuits related to official acts.
Okay, for official acts, what about before they were president or unofficial stuff?
Right. This absolute immunity does not extend to civil actions based on alleged conduct that occurred before the president took office, or conduct completely unrelated to presidential duties, even if the suit is brought while they are in office. Remember Clinton v. Jones. Nor does it protect against compliance with a subpoena in federal or state criminal proceedings.
Right, U.S.C. Nick.
Exactly. Compliance with a congressional subpoena involving personal matters is also possible, though it's subject to balancing tests and potential court restrictions. Additionally, members of the executive branch generally enjoy a qualified executive privilege regarding the disclosure of confidential information like internal deliberations to the judiciary or Congress. This privilege is qualified, not absolute, and can be overcome by a showing of specific need, balancing the need for confidentiality in executive deliberations with demands for transparency or evidence in legal proceedings. The Federal and State Powers Overview, Chapter 5.
Now let's zoom out a bit to Chapter 5 for a quick overview of federal and state powers. This is really about the fundamental division of authority in our federal system and how the 10th Amendment and Supremacy Clause define this relationship. It's like looking at the architectural plan for how power is distributed in the U.S. government.
This chapter is absolutely critical for understanding the architecture of American federalism and how our system actually works on the ground. We can broadly categorize powers into three types. First, exclusive federal powers are those that only the federal government can exercise. Think about declaring war, entering into treaties, coining money, and the naturalization process for citizenship. These are uniquely federal domains.
Okay.
Then we have exclusive state powers, the most prominent of which is the general police power, the broad authority to legislate for the health, safety, and welfare of their citizens. This is the power we discussed earlier that Congress doesn't have inherently.
Right, the general welfare power for states.
Exactly. Finally, concurrent powers are those exercised by both the federal and state governments, such as the power to tax or to establish courts. Both levels can operate in these areas simultaneously.
So when both federal and state governments have the power to act in a certain area, like taxation, how do we resolve conflicts? What happens if a state law directly contradicts a federal law?
That's where the Supremacy Clause of Article 6 comes into play. It's the constitutional tiebreaker. It states that the Constitution, federal laws made pursuant to it, and treaties made under the authority of the U.S. are the supreme law of the land. So when there is a direct conflict between valid federal and state law, or when federal law preempts state law, which we'll get to, federal law is supreme. State law must yield.
Okay, federal law wins in a direct conflict.
Yes. Then there's the 10th Amendment, which limits federal power, or rather restates the principle of limited federal power. It reserves powers not delegated to the federal government by the Constitution, nor prohibited by it to the states respectively, or to the people. This amendment is often cited as a bulwark of states' rights.
But how strong is it in practice?
Well, that's the key question. Its practical impact has been significantly limited by broad interpretations of Congress's commerce and spending powers. In essence, the 10th Amendment largely serves as a tautology, affirming that Congress can only act within its enumerated powers rather than creating a truly substantive, independent restriction on those powers once they are found to exist. It's more of a reminder of the federal structure than an independent limitation in most modern contexts. Intergovernmental immunities, Chapter 6.
Continuing our exploration of the delicate balance between federal and state governments, Chapter 6 delves into intergovernmental immunities. This section asks a fascinating question. Can states regulate or tax the federal government, and vice versa? It's like navigating a complex dance of legal boundaries between sovereigns.
Indeed, it's an intricate set of rules designed to prevent one level of government from, well, unduly interfering with the operations of the other. Let's start with federal immunity from state regulation and taxation. States generally cannot regulate the federal government or its activities. This is a fundamental principle stemming from the Supremacy Clause, often traced back to McCulloch v. Maryland.
Can't tax the bank.
Can't tax the bank, exactly. States can regulate the federal government only when Congress explicitly permits it, or perhaps when the state regulation is non-discriminatory and doesn't substantially interfere with federal policy or functions. This protects federal operations from being crippled or controlled by state laws.
Okay. And taxation.
Similarly, the federal government and its instrumentalities, like federal agencies, federal buildings, federal contractors in some cases, are immune from direct taxation by the states. The key exception here is for generally applicable indirect taxes that do not unreasonably burden the federal government, such as a state income tax applied to federal employees, taxing the employee's income, not the federal payroll directly, or a general sales tax that federal employees might pay. These are generally permissible because they tax the individual or transaction, not directly the federal entity itself.
So the federal government is largely shielded from state interference. What about the other side of the coin, state immunity from federal regulation and taxation? Can the federal government command or tax the states themselves?
When it comes to federal regulation of states, the federal government has virtually unlimited power to regulate the states directly, provided Congress is exercising one of its enumerated powers, like the Commerce Clause. So generally applicable federal laws, like minimum wage laws, can apply to state governments as employers.
But there's a big but, right?
Yet there's a huge but, a crucial constitutional limitation that's often tested: the anti-commandeering principle. Congress cannot commandeer state legislatures by forcing them to enact specific legislation, nor can it command state executive officials to enforce federal laws directly against private citizens.
So Congress can't make states pass a law or make state police enforce a federal gun law, for example.
Exactly. That principle is vital for federalism. It's essentially the Supreme Court telling Congress, you can regulate states directly and you can regulate private activity yourself, but you can't just deputize state governments to implement your federal programs for you. It protects state sovereignty even when Congress has valid enumerated powers. Think New York v. United States, nuclear waste, or Prince v. United States, handgun background checks.
That sounds like a significant limitation on direct federal power over states.
Wow.
But what about federal funding? Can Congress use that to influence state actions, even if they can't directly command them? That seems like the main way they do it.
Yes, that's the workaround, and it's powerful. Congress can regulate or influence states indirectly through conditional funding, which is a very frequently used tool. But these conditions are not absolute and must meet several criteria to be valid, as we touched on earlier. The condition must be for the general welfare, it must be unambiguous, it must relate to the federal interest in the particular program, it must not induce states to act unconstitutionally, and finally, the condition must not cross the line from encouragement into outright coercion, the point where pressure turns into compulsion.
Right, that coercion limit from the ACA case again.
Exactly. As for federal taxation of states, the federal government may tax states, but states do have a partial immunity from direct federal taxation that would unduly interfere with the performance of their essential sovereign functions of government. This protects the core operations of state governments from crippling federal taxes that could effectively destroy their ability to function, though this immunity is fairly narrow in practice. 7. State regulation and taxation of commerce, Chapter 7.
Chapter 7 takes us into a very important and frequently tested area: state regulation and taxation of commerce. This is where the concept of the Dormant Commerce Clause comes into play. What happens when states try to legislate in ways that impact interstate commerce, especially when Congress hasn't stepped in to regulate that area?
The Dormant Commerce Clause, DCC, is a critical implied limitation on state power, even when Congress has not acted, hence the term dormant. This judicial doctrine restricts the power of states to legislate in ways that unduly burden or discriminate against interstate commerce.
So it's inferred from Congress's power, even if Congress is silent.
Exactly. The idea is that Congress's power over interstate commerce is partially exclusive, and states can't mess with it too much. If Congress has not enacted legislation in a particular area, states can regulate local aspects of interstate commerce, but only if their regulation does not: 1. Discriminate against out-of-state commerce; 2. Unduly burden interstate commerce; or 3. Purposefully regulate wholly out-of-state activity. The underlying principle is to prevent states from engaging in economic protectionism that hinders the free flow of goods and services across state lines, creating a unified national market.
So discrimination against out-of-state commerce is generally a big no-no for states under the DCC. When, if ever, is that kind of discrimination permitted? It sounds like almost never.
A state or local government cannot enact a regulation that is purposefully discriminatory, meaning it protects local economic interests at the expense of out-of-state competitors. Such regulations are subject to something very close to strict scrutiny, and they are almost always struck down.
Almost always. Is there an exception?
There's a very rare exception. The state must prove that the regulation is necessary to achieve an important non-protectionist state interest, and that no non-discriminatory means are available to achieve that purpose. This is an incredibly difficult standard for a state to meet, showing how strongly the court disfavors economic protectionism by states. Think about cases involving quarantines for diseased products. Maybe, but it's rare.
Okay. And what if a state law isn't discriminatory on its face? It applies equally to everyone, but it still seems to create a significant hurdle or cost for interstate businesses compared to local ones.
That's where the undue burden on interstate commerce test comes in, often called the Pike balancing test. A non-discriminatory state regulation may still be struck down if it imposes an undue burden on interstate commerce. To determine this, a court will engage in a balancing act. It will weigh the legitimate local benefits that the state law aims to achieve against the burden it imposes on interstate commerce.
So benefits versus burdens.
Right. The court will also evaluate whether there is a less restrictive alternative available that would achieve the state's legitimate purpose with less impact on commerce. If the burden on interstate commerce clearly outweighs the local benefits, the law is likely unconstitutional, even if it's not discriminatory. This requires a careful factual analysis by the court.
Are there any specific situations where states can discriminate against or burden interstate commerce, even if it seems to violate the Dormant Commerce Clause? Any major exceptions?
Yes, there are 3 important exceptions to the Dormant Commerce Clause where states get more leeway. The first, and probably most significant, is the market participant exception. If a state is acting as a buyer or seller in the market itself, rather than merely as a market regulator imposing rules on others, it can favor its own local commerce or discriminate against non-resident commerce.
Like a state university charging lower tuition for in-state residents.
Exactly. Or a state-owned cement plant preferring to sell to in-state construction projects first. When the state acts like a private business in the market, it's generally free from DCC constraints for that specific transaction.
Okay. What are the others?
The second is sometimes called the traditional government function exception, though it's less common. State and local regulations can favor state and local government entities, but not private ones, if those entities are performing a traditional government function, such as waste disposal services. And finally, congressionally permitted discrimination. An otherwise impermissible state regulation becomes perfectly valid if it is unmistakably clear that Congress intended to permit that state discrimination or burden on interstate commerce. Congress, having the ultimate authority over interstate commerce, can authorize states to do things that the Dormant Commerce Clause would otherwise prohibit.
Congress can override the dormant part.
Exactly. If Congress speaks, the dormant doctrine yields.
Beyond regulation, states also have the power to tax commerce. How does this apply to interstate commerce, and what are the limitations there? Similar test.
States may tax interstate commerce, but again, with important limitations to prevent discrimination and undue burdens. This is permissible only if Congress has not already acted to preempt state taxation in that area, and the tax itself satisfies a four-part test from the complete auto transit case.
Okay, 4 prongs.
Right. For a state tax on interstate commerce to be valid, 4 conditions must generally be met. First, there must be a substantial nexus between the activity being taxed and the taxing state, a real connection. The business must have a sufficient presence or activity there. Second, the tax must be fairly apportioned pursuant to a rational formula, ensuring that interstate commerce doesn't pay double or multiple taxes on the same income or activity in different states. It has to reflect the share of activity actually in the state. Third, the tax must not discriminate against interstate commerce, either on its face or in its practical effect, so there's no direct commercial advantage for local businesses. And fourth, the tax must be fairly related to the services provided by the taxing state, such as police and fire protection, roads, courts, things the taxed business benefits from.
Substantial nexus, fair apportionment, no discrimination, fair relation to services. Got it. What about property taxes, especially on goods that move between states or on the instrumentalities of commerce, like trains or planes that cross state lines all the time?
When it comes to ad valorem property taxes, taxes based on the assessed value of property states can tax movable commodities, known as goods in transit, only if they have come to rest or acquired a taxable situs within the state on tax day. They cannot tax goods that are merely passing through in transit. States can also tax instrumentalities of commerce, like trains, airplanes, or barges, but only the portion reflecting the contacts or presence within the taxing state. The tax must be fairly apportioned based on factors like mileage traveled or time spent in the state.
So you can tax the value related to the state's connection.
Right, the portion attributable to the state. And foreign commerce. Can states tax imports or exports, or is that primarily a federal domain?
For foreign commerce, states face even tighter restrictions due to the Import-Export Clause of the Constitution. A state must have congressional consent to impose taxes on imports or exports. The very narrow exception is if the tax is absolutely necessary for executing the state's legitimate inspection laws. This significant limitation ensures that states don't interfere with federal foreign policy or international trade agreements, which are typically areas of exclusive federal authority. Federal preemption of state law, Chapter 8. Chapter 8 moves us into federal preemption of state law. This is about when federal law essentially takes precedence and negates conflicting state or local laws. It's a critical concept for understanding the hierarchy of our legal system, particularly when both levels of government seem to have power over the same subject matter.
Indeed. Preemption occurs when federal law supersedes state and municipal laws. It's a direct application of the Supremacy Clause we talked about earlier. There are 2 primary categories, each with important nuances you need to recognize: express preemption and implied preemption.
Let's start with express preemption. That sounds pretty straightforward. Congress just flat out says no state laws allowed here in this area.
That's exactly right. Express preemption happens in 2 clear scenarios. First, although rare, sometimes the Constitution itself makes federal power exclusive in a certain area, implicitly leaving no room for state action, like coining money. Second, and much more commonly, express preemption occurs when Congress has enacted legislation that explicitly prohibits state regulation in the same area. The federal statute will literally contain language stating that it preempts state law or that federal regulation is exclusive. It's the clearest form of preemption because congressional intent is stated right there in the text.
Easy enough to spot if it's there. And what about implied preemption? This sounds a bit more nuanced, where Congress hasn't explicitly stated its intent to preempt, but the effect is the same. How does that work?
Implied preemption occurs even when Congress hasn't explicitly stated its intent to preempt state law. The intent is inferred from the structure and purpose of the federal law. There are 2 main types here that you should know. First is field preemption. This arises when Congress's regulation of a particular area is so pervasive, so comprehensive, that it shows a clear intent to occupy the entire field, leaving no room whatsoever for state regulation, even if the state law isn't in direct conflict. The federal regulatory scheme is so dominant, or the federal interest so overriding, like perhaps immigration, that it implies Congress wanted to be the sole authority.
So even compatible state laws are out if Congress took the whole field.
Correct. The second type is conflict preemption. This occurs in two situations.